If you ask your average high school student to recite the Bill of Rights, you would usually hear freedom of speech, the right to bear arms, and the right to assembly, I think. Following the Revolutionary War with Great Britain from 1775 to 1783, much of the newly established American government feared that the rights they had just fought so hard to achieve would be ignored and trampled upon. Before the passing of the Bill of Rights, the Constitution contained scarce reference to the unalienable rights that the citizens of the United States had just finished fighting a war over. Startled by this, the Anti-Federalist Party persuaded the Federalists to include the Bill of Rights within the Constitution. It was only under this condition that the Anti-Federalists adopted the Constitution. Within the colonies, the act of finding and paying an attorney went from being looked down upon as unnecessary to being quite common as the courts began hiring professionally trained prosecutors. However, it was not until the Bill of Rights passing in 1791 that an attorney being appointed to you by the courts without commission became a possibility. Today, the Sixth Amendment, and more specifically the right to counsel, lays out to anyone who has been charged with a felony their right to an attorney. At any junction in which you are being interrogated for a crime or are facing arrest, you reserve the right to an effective attorney appointed to you by the courts. This was not always the case, however. Originally, the right was given only for capital and federal cases. This means that when originally passed, unless you were without funds or unable to represent and defend yourself within the federal court, or facing death, that court was not obligated to supply you an attorney. This left countless accused citizens in the dust.
Suppose you are convicted of the manslaughter of your neighbor. This felony would be sent to state court, where you are left to your own devices to acquire an attorney. Imagine you are already on probation, and you could be facing issues such as losing custody of your children, or losing the money you could be putting into your house or insurance to pay for an attorney. Suppose you are comfortably middle class and you are accused of a state felony, and you are deemed able to afford your own defense. You could be working on paying off your student loans or putting your own kids through school, and you decide to represent yourself. There is no doubt that unless you have had years of training in the law, there is significantly less likelihood that you will be successful in the case. On top of all these scenarios, there is the looming possibility that you could have been wrongly accused. This gray area of the accused who were not facing capital or federal charges were unable to find aid from what were once called our unalienable rights.
Luckily, since the passing of the Bill of Rights, a few changes have been made to the highly exclusive original Sixth Amendment. The groundbreaking Gideon v. Wainwright case of 1963 was a landmark in terms of the amendment's adoption. In January of 1963, Clarence Gideon came before Florida courts charged with a non-capital felony, one not punishable with the death penalty. He was unable to afford his own representation and was not appointed counsel as he was not charged with a capital felony. Gideon applied to the state Supreme Court, arguing that this denial of counsel violated his constitutional right. However, he was still denied an attorney and was imprisoned. 20 years earlier, in the Betts v. Brady case, Betts came before the Maryland State Court charged with robbery and without sufficient funds. The Maryland State Court ruled that unless illiterate or incompetent, there is no obligation to supply the accused with representation, and Betts was left to defend himself. This ruling still held even after Betts applied to the Supreme Court, arguing that he was a victim of unlawful arrest as he was not granted counsel. It was not until Gideon v. Wainwright's 1963 conclusion that this decision was overruled. While Gideon was still imprisoned, the right to counsel was finally expanded to include both federal and state felonies.
America today holds the title of the country with the most incarcerated citizens, with upwards of 716 out of every 100,000 citizens in state or federal prison. This is not a reputation we should be proud of, and every day a different tragic story comes forward of an innocent citizen who was wrongly accused and put away, sometimes for life. Even those citizens who have been already incarcerated and have later been shown through testing to be wrongly convicted spend upwards of 13 years in prison on average. Without the Sixth Amendment, our already mind-numbingly high amount of incarcerated citizens would go through the roof. with overpopulated prisons becoming even more grim and ineffective, as they oftentimes are today. The only way to stop this from happening is by having sufficient representation of all accused citizens, which would not be possible without the aid of the Sixth Amendment. Today, while the amendment has grown to include a need for an effective attorney, there is still a wide gap between the quality of the state-appointed attorney and the highly trained and widely recognized government attorneys that wealthier accused criminals could afford. The American court system would never be truly equal until all aspects of amendments, such as the Sixth, have been equalized to apply fairly to all American citizens.